Okay, thank you very much. So now we have Professor Amalia Amaya from the Autonomous University of Mexico, and now she's in Edinburgh as a long-term visitor, isn't is it?
Yeah.
Okay, so it's wonderful to know actually that you're there. Amalia, thank you very much for coming, for joining us. Amalia will be speaking about group disagreement in a paper that we just put a draft on the website, so you can all hear and discuss. And we have Conrado Hubner Mendes to give her some feedback and some comments on the paper. Okay, thank you very much. This meeting is part of a series of seminars that we organize by the Federal University of Minas Gerais and partner institutions. We have a network of law and political philosophy. So thank you very much, Amalia, and we will now give the floor to you so you can just present for us the paper. Thank you.
Okay, so thank you very much, Thomas, for this invitation to share my work and discuss it with you. This is part of a bigger project. My project is the main project in which I'm working on now is on virtue, legal reasoning, and legal ethics. So what I'm trying to do is to develop a virtue approach to legal reasoning and show the extent to which it is intertwined with topics in legal ethics, so that actually looking at legal reasoning from a virtue perspective allow us to see some important dimensions of legal argument that are usually neglected or at least marginalized in standard theories of legal reasoning, and it also helps us see the extent to which the topic of legal reasoning is actually connected with themes in legal ethics. So this is the broader project. And what I would like to discuss with you today is a small part of this project that is very much in progress, which is the collective dimensions of legal argument and how virtue can help us improve upon legal reasoning in collective sites of legal reasoning. So the book will focus mostly, as in fact most literature in legal reasoning does, on the individualistic individualistic approach to legal reasoning. So the focus is mainly on the virtues that legal officials and legal decision makers should have to engage properly in legal reasoning. So it's mostly from the perspective of the individual deliberator, but I would like to touch upon the collective dimensions of knowledge to some extent in the book, and part of this is what I'm going to be presenting here. Let me just 1 second take my watch so that I can time myself. Okay. So in this paper, the objective is to see the extent to which a virtue approach can help us shed some light and understand better and improve upon collective instances of legal reasoning, more specifically, how to tackle group disagreement in law. So this group disagreement is a pervasive phenomenon in law. Many sites in legal decision making, many instances of legal decision making are collective in the sense that they are taken by groups. I'm sorry that my voice is a bit damaged today, not because of COVID, happily, as far as I know at least, but yeah, I had a little bit of a cold and my voice is still recovering. So many decisions, as I said, are taken in the context of law by collectives, by groups, rather than by individuals. Of course, the courts, the constitutional courts, but also regulatory agencies, parliamentary commissions, councils. So there are many situations in which legal decisions are taken by groups rather than by individuals, and this makes problems of group disagreement salient in law. And a problem that really needs to be attended and tackled. So what I'll try to do here is to see the extent to which virtue theory can help us tackle the problem of group disagreement. The first the first option that will come to mind when it comes to tackling and addressing problems of group disagreement in law will be to extend the model that is dominant in epistemology, which is the peer disagreement model. This is the dominant model in the epistemology of disagreement, which by now is even a subdiscipline in itself. However, I think that this is not a very promising venue for addressing problems of disagreement in law for various reasons. First of all, because it tackles disagreement from an individualistic perspective. So it is individualistically framed, the problem of disagreement in the peer disagreement model. It is also highly idealized because it deals with problems of disagreement as they occur between two cognitive agents that are epistemic peers, that have roughly the same access to evidence and capacities, and epistemic capacities. And thirdly, because it focuses only on a very specific segment of the whole process of disagreement. So the moment at which the person who is disagreeing with a peer has to decide what to believe, whether he or she should conciliate and downgrade the degree of belief in light of the disagreement with an epistemic peer, or whether, to the contrary, instead of conciliating, she should stick to her beliefs, as the steadfast position in the peer disagreement debate suggests. So it doesn't deal with questions such as when do I consider someone as a peer disagreement, as someone who is a peer for the purposes of disagreement, or how the disagreement has to be registered after the disagreement has been resolved. And problems that happen before the peer disagreement model comes into scene, and problems that happen after, are extremely important in law as well. If we think of the practice of dissenting judgment, this is one example of how important it is the post-decisional moment, and not only focusing on exactly the decisional moment. So because of that, I suggest that we look at disagreement from the perspective of virtue theory, rather than trying to extend the peer disagreement model as it has been suggested in the literature. So the claim that I would like to argue for is that the possession and exercise of the virtues on the part of the deliberative virtues on the part of individual deliberators that are members of a group help us mitigate some of the deliberative distortions that give rise to situations in which groups either fail to agree or reach agreements that are not epistemically valuable. So basically the argument is the following. There are a number of problems of deliberative distortions or deliberative biases that impinge on group deliberation. The operation of these biases give rise to some problems concerning disagreement. So situations in which either groups fail to agree, or situations in which the agreement is reached in an epistemically disputable or controversial way. And the virtues help us mitigate the problem of disagreement by attacking those deliberative biases. So that is the argument. So I'm not aiming to solve all the problems of disagreement, but only those that have their origin on the operation of these deliberative biases. So what I will do, my argument will then proceed in 3 steps. First of all, I'd like to explain a little bit what these deliberative biases are and how they affect the problem of disagreement within groups. Secondly, I will explain what are the deliberative virtues and how they help us mitigate those biases. And last, I will try to discuss some objections that may be raised against the proposal to address group disagreement in law by using virtue tools. So let's get then started with the first part, that is, what are the deliberative distortions or deliberative biases, and how they can how they affect the problem of group disagreement in law. So the decision power is allocated to groups because as the wisdom of crowds has it, and it's a very popular book, both a book and a way of referring to the extent to which there are epistemic advantages in allocating decision-making power to groups. Oftentimes, groups take decisions that are better than those that would have been reached by solitary deliberation. So there is an epistemic rationale for, apart from a political one, of course, for investing with decision-making power, to invest in groups with decision-making power. However, there is a substantial empirical evidence, and more even so because there has been an increasing interest in social psychology recently, and moving from the paradigm of cognitive psychology and the study of biases that affect individual reasoning, and trying to understand better the group dynamics and how these affect as well collective reasoning. There is also a substantial empirical evidence showing that group deliberation sometimes goes really bad, and sometimes decisions taken by groups are not only better than those that would have been reached by solitary deliberation, but rather are even worse that the median member of the group would have reached. And in that sense, it is important to structure group deliberation so that it actually, the gains of allocating power, decision-making power to groups, offset the potential losses that might happen when some of these deliberative distortions impinge or distort group deliberation. So what are these distortions? The first one is amplification. There is substantial empirical evidence showing that many of the biases that we all know, the individual biases that distort group individual deliberation, are actually amplified when we move from the individual context to the collective context. It's interesting, and I really wanted to have read about that more in depth before this talk, but I didn't have the time to. If you know about this a very important book that just came out, I'm going to show it to you. In fact, this book, Noise, by Sustain and Kahneman and Oliver Sibony, even all this new empirical evidence about noise and factors that interfere that are noise in the sense that they interfere in processes of decision making in many domains that are irrelevant reasons that shouldn't be playing a role. Even those are also amplified in context of group deliberation. So this is a main problem that leads groups astray in collective sites. Secondly, there is a problem of suppression. And the problem of suppression is that individuals within group self-silence. They self-silence because of social reasons, because the fear of sanctions, of social disapproval, of being ridiculized, or because of informational reasons, because they think that given that they are in a minority, they might be wrong. It's likely that the majority got it correctly, and therefore, since I disagree with most people within the group, I might be wrong. So these two forms of suppression or self-silencing makes it the case that the group takes decisions based on only a subset of the reasons available within the group, as opposed to being able, the group, to take into account all the different, the diversity of views that are held, and all the body of evidence that is available within the group. So it only benefits from the views that are held by some individual members, but not by all members of the group. The third problem is homogenization. And this is the problem also very well documented, and very well documented in law specifically, according to which the consensual view within the group tends, and the views that get discussed tend to be the majoritarian views rather than the minority voices. So this problem, as a result, there is an homogenization of the views within the group because alternative views do not get discussed or do not have the same potential for influencing the consensual view within the group. So there is a shift towards the majority view rather than the final agreement being informed by all the different views that are discussed within the group. The fourth problem is the problem of polarization, which I am sure many of you have already are familiar with because it's been so much into the political debate nowadays. So that is the problem of decisions of deliberative tendencies of individual members becoming intensified and polarized, radicalized in the process of group deliberation, so that individual members end up endorsing more radical versions of the views that they had before the group deliberation started. So instead of the group converging into a view, what happens is that there is even more a radical divergence between the different views that are held within the group, and with the result that, of course, the group is not able to reach an agreement. And finally, there is the problem of domination. And this is the problem in which, unlike in homogenization, in which all views tend to converge or are swollen up by the majoritarian view, in domination, there is a shift of the different views within the group towards the view that is held by those socially privileged members within the group. So it is social privilege translates into an increased credibility, and this makes it the case that those who are socially privileged or experts or belong to the favored gender or the favored racial group or the favored ethnic group tend to have more of a say in what the consensual view is going to be at the end of the deliberative process. So these five types of deliberative distortions have a deep effect on the ability for groups to reach agreements that are epistemically valuable. First of all, there are two kinds of deliberative failure, I think, that can be associated with these five types of deliberative distortions: a failure to agree and a pseudo agreement. So the failure to agree is because of these forces, more obviously because of polarization. Groups fail to agree, with the result that we get deadlock courts or hung juries. The second type of deliberative failure that I think is associated with these five types of deliberative distortions is the case of pseudo agreement. Or forged agreement, counterfeit agreement. I'm still trying to find like the best name for that. But that will be cases in which the agreement that is reached by the end of the process, in fact, is an agreement that is not properly informed by the whole set of reasons available within the group. So that I would like to go one step further and say it's an epistemically unjustified agreement to the extent that it doesn't take into account all the evidence that is available within the group. So this type of pseudo agreement happens in cases, for instance, the polarization, as I said, radicalizes disagreement and leads to one of the deliberative failures, the failure to agree. And the pseudo agreement may result as a result of suppression, homogenization, or domination. In these cases, the agreement, that final agreement, is based on less than the whole of the reasons, of the set of reasons available, either because individual members self-suppress their own views, self-silence, or because minority views are not taken and discussed seriously because of the homogenization effect, and also because those views that are held by minority groups, in the sense of groups that belong to socially disadvantaged members who belong to socially disadvantaged groups, will also not have the required influence in the final agreement. So it's only responsive, the final agreement, to a subset of the reasons available within the group, and to the extent that this is so, it's not a proper agreement, but rather a pseudo agreement. We seem to agree, but only because, of course, some people do not speak up, or because some views are not taken seriously. So this is not to say that all problems of agreement can be traced back to the operation of these 5 deliberative failures. So there are cases, of course, in which the failure to agree has nothing to do with polarization, but because there is a genuine deep disagreement within the group. But when a disagreement intensifies, there is always polarization involved. And to the extent that this is so, by targeting polarization, we are at least targeting a significant, a substantial portion of the cases in which there is a failure to agree, even if we do not, we cannot hope to solve them all. And similarly, there are situations in which there is a pseudo agreement rather than a real or genuine agreement that is reached as a result of group deliberation for reasons that have nothing to do with suppression, homogenization, or domination. For instance, because there is a political agenda within the court, or because there is a political compromise. So there is not a genuine agreement in that sense, but the reason has nothing to do with domination or homogenization, for instance. But nevertheless, by attacking problems of polarization, domination, and homogenization, we are also, and that's the plan, to attack a significant portion of the cases in which pseudo-agreement rather than genuine agreement is the result of group deliberation. So what I like to suggest, and this is the second part, is that group, and I'll go a bit faster then, or maybe just keep the objections for the discussion because I'm talking a bit too much. So what I like to suggest is that group deliberative virtues can help us mitigate the problems involved in these deliberative distortions, and by doing so, they can help us avoid situations in which there is either a failure to agree or situations in which pseudo-agreement or counterfeit agreement rather than genuine agreement is reached as a result of group deliberation. So I disappear just for them. So what are these deliberative virtues that I think are helpful devices to tackle these deliberative distortions? These are traits of character that lead groups to reach epistemically valuable outcomes, so justified group beliefs or true beliefs, in that they enable a genuine and productive group deliberation. And there are different types of deliberative virtues. So virtues that contribute to group synergy. I think that we all have had experience, like in committees at the university, of when a group has a good group synergy and when to the contrary there is none. And this is of course related not only to the outcomes the group reaches and how epistemically justified those outcomes are, but also by the process whereby decisions are reached. Ideally, when a group strikes a positive synergy by a reason exchange of arguments. So what are these deliberative virtues that enhance group synergy and help groups arrive at epistemically justified outcomes? So first of all, I like to suggest that there are moral virtues such as friendliness, civility, or temperance, which are helpful for creating a deliberative environment in which it is more likely that this reason exchange of arguments proceeds in an impended form. In addition to moral virtues, there are also epistemic virtues such as open-mindedness, intellectual humility, or perseverance, and this is mostly the type of virtues that have been associated to deliberative virtues in the literature, and I think of course these are critically important, but there are also the traits of character that are important for ensuring that groups reach good deliberative outcomes. In addition to both moral and epistemic virtues, there are argumentative virtues, such as willingness to question the obvious, the willingness to modify one's views in light of other people's arguments, or a willingness or disposition to listen to others. So these are some of the argumentative virtues that have been beautifully discussed, I have to say, in very interesting terms in the literature in argumentation theory, and that I think can be brought up, can be put in connection with deliberative virtues in a fruitful way. And finally, there are also a number of virtues that are the communicative virtues, mostly the discussion of which mostly comes from the field of communicative ethics, such as sincerity, receptivity, or clarity, that given that the group deliberation is not only an argumentative practice, of course, but also a communicative one, are also relevant for enhancing the quality of group deliberation. These types of virtues are not like self-isolated or isolated compartments, but rather they should integrate. There are important connections between these different virtues, and they integrate into through the virtue of practical wisdom that has this mediating power, they integrate into what will be like an ideal deliberator. So these are traits of character that are not independent from one another, but there are important connections between them. I will not go into detail into that, but think, for instance, that although of course there are also moral reasons, there are moral reasons to there are epistemic reasons, to be open-minded, being open-mindedness being an epistemic virtue. Of course, there is an epistemic rationale to being open-minded, but there is also a moral one, in that the person who is open-minded will give two minorities a voice. Or kindness is a moral virtue, but it's also epistemically relevant, because if there is an environment, a deliberative environment in which people are kind to each other, then it's more likely that people will share evidence and arguments. And be open to alternative viewpoints. So there are important connections between these different types of virtues. So these virtues, and I'm hoping to close in 5 minutes. Sorry about the extended time. Or even less, these virtues, I would like to claim they play a corrective role of these deliberative distortions. So they help us avoid or minimize situations in which there is a failure to agree, or in which there is pseudo-agreement, by mitigating the import of these different deliberative distortions. So some virtues, for instance, minimize polarization, if we think of temperance or politeness, suppression, for instance, courage, and so that one will not think that, or intellectual autonomy, better, in which one doesn't think that one should be wrong given that I'm in a minority, but if one is intellectually autonomous and courageous enough, will be able to speak out and expose one's minority's views within the group. Or homogenization, for instance, by a willingness to question the obvious. This is an important argumentative virtue, and therefore I will feel less tempted to feel the magnet of the majoritarian group vision of within the group, if I have this willingness to question the obvious, to question shared beliefs, or inquisitiveness, or intellectual vitality, like other traits of character that are important to actually scrutinize those shared beliefs within the group, and so that they do not dominate the discussion. And for mitigating domination, virtues such as, for instance, epistemic justice, that is one of the virtues that has been discussed so much in the literature lately, will be important for preventing situations in which loss of credibility is associated to having a socially perceived lower status. So the virtues help us bring deliberation in the direction in which it is less susceptible to fall in prey to these deliberative distortions, and as a result of that, it minimizes situations in which there is either a failure to agree or a pseudo agreement is reached as a result of group deliberation. So this is the suggestion. I think there are some serious objections that have to be dealt with, and I suggest I articulate some of these objections in the last part of the paper, and I suggest some ways in which they can be addressed, but maybe some of those will come up in the discussion, so I will stop here. Thank you so much for listening.
Thank you very much, Amalia. This is a fascinating paper, and I think there's a lot to discuss. But before opening the floor to questions, I would like to hear Conrado's comments. Conrado is our guest today to comment on Amalia's paper. He is a long partner of us. We've done many things together, and I hope that we continue doing it. Conrado is a professor of constitutional law at the University of São Paulo. And now it's your turn, Conrado. Welcome.
Amalia, it is great to see you, and especially to know that you are in Edinburgh debating a topic that was also the subject of my PhD that I did in Edinburgh. And first of all, I just apologize if my connection, which is unstable, sometimes I basically fall of the call, and I come back certainly in 30 seconds. But let's start the discussion. Amalia, I wrote, it's impossible for me to elaborate my comments without trying to contrast or to engage with my arguments in my PhD thesis, which has become a book a few years later. And my PhD tried to understand constitutional courts as deliberative bodies, and more than that, try to elaborate a complementary argument, a complementary case for the legitimacy of constitutional courts based on their supposed deliberative qualities and abilities. So to put it short, my ultimate argument was to say that deliberation is not something that we can assume, that we can take for granted. Deliberation is an achievement to be reached in each case, and the legitimacy of a constitutional court can be discussed and assessed on the basis of what I call the deliberative performance of courts. And I try to devise some sort of a set of criterion of what I call deliberative performance. So my take on the debate is that, well, we cannot basically assume that courts are legitimate because democracy is not just about majority rule, etc., which is a mainstream argument, but we can justify, but it is also a sort of consequentialist way of justifying the legitimacy of constitutional courts. But this is just an overall picture, because I try to engage not with this depth and not, unfortunately, not engaging very much with the literature of virtues of social psychology and epistemology of disagreement, but a little bit with legal reasoning based on virtue and deliberative democracy. And my thesis, I draw a few distinctions which I think are important, and in 2 minutes I'll show how they connect to your point. Well, the first common distinction to discuss deliberation is about the justification for deliberation, why deliberation is desirable, and there are intrinsic moral reasons for deliberation and instrumental and consequentialist reasons for moral reason. The second distinction, and I'll explain and raise a few questions. The second distinction, which I think was something, I'm not sure it was original, but it was a way of trying to address the tension between instrumental and intrinsic reasons, the distinction between first order and second order deliberation. And then I, thinking about this particular institutional setting of a constitutional court, I sort of decompose what I call deliberative phases of courts. There is the pre-decisional, the decisional, and the post-decisional sort of deliberation. And so on the distinction between intrinsic and instrumental reasons, I think that, well, of course, there is good moral reason to think that deliberation is an end in itself, regardless of its consequences. And there is a way of arguing that deliberation is desirable because it brings up desirable consequences. These consequences can be epistemic, but not always epistemic. Sometimes, even if not the best solution, a consensual solution is a good sort of communitarian achievement. Sometimes there are educational benefits of deliberation and so on. But both for in the moral reason side, but also in the instrumental reason side, there is a flip side to the story. There are also good moral reasons against deliberation and good consequentialist reasons against deliberation. And my way to see them, it is not easy, or it is not possible to take a stand on which reasons you embrace at this abstract level without discussing the particular sites you are deliberating. Those reasons will be stronger or weaker depending on who the
Conrado, I think, Conrado, could you repeat yourself? We lost you.
So, do you now?
Hold on,
Yeah.
just wait. Yeah, now it's okay. I think that we
Okay.
lost you when you were saying that we should not consider things only at an abstract level. We should
Yeah.
to more
yeah.
specific values. Yeah.
To some extent, in order to take a stand, it is only possible to take a stand on this debate by talking about a particular decisional site, by a particular institutional or any sort of setting. So at the abstract level, you cannot take that stand. But then let's think about the particular site of a legal decision-making body, a constitutional court or whatever sort of court. And one way, I think, to try to solve what I think is a tension between intrinsic and instrumental reasons, because my sense was that although the intrinsic reasons are strong, sometimes when there is a big risk of really dangerous consequences, sometimes the instrumental reasons outplay the intrinsic reasons. It depends very much on particular situations. And in this way, I thought it was important to claim that an institution, especially a privileged setting, institutional setting, can organize itself in order to be able to do not only the first order deliberation, which is deliberating on the particular subject matter it has to decide. So a particular constitutional case, whether this is constitutional or unconstitutional. But I thought it was interesting to think, and I'm not sure I'm stressing the notion of deliberation by calling it deliberation, but the second order deliberation is a way for the deliberative body to ask itself whether it is worthwhile engaging in deliberation. At this second order level, you can actually investigate how much on that particular context deliberation is promising or it is dangerous. And just to summarize, basically what a second order deliberation will ask first is whether, well, it is more urgent to decide than to deliberate deeply and take the best possible decision. That's one sort of second order question. There is a second sort, which is, well, we have already decided many times. So for economy reasons, let's just let with the past. Let's just let with precedents. Let's not open it again. Whether, I don't know, whether torture or the death penalty is constitutional. Sometimes it's undesirable to open this sort of deliberation. And another thing which also echoes from a literature on post-conflict and very divided societies. In very divided societies, it is arguably dangerous to deliberate because they polarize even more. They put fire on conflict, etc. And I think these are still abstract, but I think sometimes the particular deliberative institutions can do this sort of division. But let's get to the point I raised regarding the deliberative phases, and I think each deliberative phase can display a particular group of deliberative virtues. So in a pre-decisional phase, a court can show deliberative curiosity towards the public sphere and the parties of the society, because this is the moment when deliberation occurs between the court and the society and the particular legal actors that are arguing before the court. At the decisional phase, when the judges actually do decide among themselves, they actually display some epistemic and as Amalia called epistemic and moral virtues, like epistemic ambition, epistemic humility, collegiality, which is very central to court and etc. And finally, the moment I thought it was important to highlight how the act of writing a legal decision can display further virtues as well, like clarity, responsiveness, and a sort of sense of fallibility and continuity. This is the way I thought we could talk about deliberative courts. In each of these phases, there was a particular goal, a particular deliberative task. I'm here almost describing all of my thesis, but I guess, and finally, I wrote a chapter on deliberative virtues, which is basically these ones I described. And there was another one on institutional design, which is something that Amalia touches upon on her paper without, perhaps without calling it institutional design, but she called sort of structural incentives. So constitutional courts can be designed to maximize its deliberative potential. Although when you see each particular institutional variable, sometimes there must be a trade-off, because there are different sorts of deliberative achievements that you might try to reach. If your deliberation goal is to reach the greatest number of different arguments, you probably won't be able to reach consensus, for example. So this is one particular trade-off. If you want to maximize the potential to reach consensus, I'm not sure the literature agrees with that, but the literature I work with argues that if you want to maximize the chances of consensus, you cannot have a too diverse deliberative body. You cannot have too much diversity. I'm not sure this is empirically consistent, but at the same time, if you want to maximize the number of arguments, don't expect consensus, but you can seek for a more diverse court. This is one particular example. There are several others, particular institutional variables that a deliberative court can try to try to reach. So taking into account the Amalia's point, I think one possible development of these structural incentives that she talks about can be to think about particular institutional design of deliberative institutions. She mentions juries, she mentions courts, and I think this is one very interesting way to test these claims. And finally, I had two points which also connected to my work. First, it is the idea of what Amalia calls as deliberative distortions. But in a moment she says, well, sometimes there are pragmatic and strategic reasons for not reaching ideal consensus and agreements, and you compromise. The word compromise appears once in her paper, and I try to decompose a little bit what compromise might be, because compromise can have different moral qualities, and sometimes it is desirable, even if it is not a first best sort of decision in epistemic terms. Thinking about this particular setting of a constitutional court or a judicial body different from a constitutional court, sometimes having a decision of the court is better than having a majority decision, for reasons of the rule of law, for political reasons, for strategic reasons, and sometimes there are good moral reasons, and sometimes compromise is also virtuous in this sense. I didn't elaborate a very precise question on this. I wanted to hear from Amalia whether she agrees and whether she would be willing to unpack this question of compromise, because compromise, one can say that it is always a sort of second best in epistemic terms or deliberative terms. It is a suboptimal sort of agreement, but still we could differentiate different sorts of compromise, and a virtuous court should and could seek the best compromise possible, so to say. I elaborated a bit on my book, but I'm satisfied with raising the question like this. Sometimes it is good for a deliberator to renounce the right to voice the dissent. Sometimes the deliberators are not sure, and there are good reasons for deferring to the majority. Not all compromises are compromises oriented by private, purely pragmatic reasons. That's my main point on this. I think I'll stop here. I just wanted to raise one final thing. Towards the end of the paper, Amalia talks about she draws a distinction between a deliberative behavior with the virtuous motivations, which is genuine virtue, genuine deliberation, and a sort of appearance of deliberation, or to elicit a deliberative behavior without the right motivations, without actually displaying virtue. And I always ask myself whether one can actually characterize true deliberation without honest and virtuous deliberators? How can, of course, the display of deliberation might have a value in itself. The display of justifications, of public reasons, etc. They might have a value in itself, even if the deliberators are not genuine and honestly pursuing the deliberative virtues. But for sure, this is already a very underplayed sort of deliberation, isn't it? Because the ultimate promise of deliberation is to sort of reach well, at least the epistemic promise of deliberation is to reach the best decisions on the basis of the capacity of the deliberators to persuade and to be convinced and so on. And at least for this more ambitious promise of deliberation, there can only be deliberation with honest deliberators and with the right motivations. The display of deliberation can reach other sorts of goals and other sorts of values, but not the most ambitious promise of deliberation, which I guess, or I think it is the epistemic one, probably. But perhaps not the most important, but one very important is the epistemic promise, and the epistemic promise only makes sense, at least with honest and with the right dispositions with regards to the deliberators. But I perhaps I spoke more than Amalia herself, and I'll stop here. Thank you, Amalia.
Okay, thank you, Conrado. I think I made a very wise choice when I put the two of you to talk together, because I don't know if Amalia knows, but at the time that Conrado wrote his book, I wrote a review of it, a long review, and I realized that he would be the best commentator for your talk, because they fit together very well. I think that the two projects, they talk to each other, and there's a lot of mutual feedback. So I open the floor to you. Amalia, after you answer, we are going to take questions from the audience. They can be either written or spoken. And perhaps if there's anyone who wants to make question in Portuguese or Spanish, we can open for that possibility too. And we, okay? So, so now I'll give you a response to Conrado, and then we open the floor. Thank you.
Well, thank you very much, Conrado, for your very rich comments. Indeed, I am very sorry that I didn't engage with your work, but I will definitely do, because there is, as Thomas said, really I think a very fruitful connections to be explored, and I will definitely benefit a lot by reading it and including it and discussing it into my argument. There is a synergy, if we may say so. So yeah, I will absolutely make sure to do that. Yeah, I mean, I go through through some of the issues. I don't think I can actually like properly discuss them all. There is like a lot that I will have to think about. But some of the points that you raised on why deliberation is desirable, and here that was like the first theme, right? This distinction between moral and consequentialist or reasons. I completely agree. Like I did say, not in the talk, but I did say in the paper in passing, that the virtuous deliberation has not only an epistemic value, but it also has moral value. And I think this is an important dimension that I actually think is important also for meeting some of the objections later that I discuss later in the second part of the paper, in that it adds to deliberation a moral texture that is extremely important. In connection with that, so I totally agree on it having both this type of instrumentalist justification, particularly in terms of epistemic outcomes, but not necessarily epistemic, and also these moral reasons. And here I only want to share my puzzlement by reading, that was, of course, ignorance on my part. I have no doubt about that. But I was really puzzled when I started reading on group disagreement about the extent to which epistemologists have this ongoing discussion about whether one should vote or deliberate. That was for me, which also replicates in political philosophy, and particularly in democratic theory. That was I thought that was puzzling, and then I read an article which I don't think it is mentioned actually in the paper on someone who was just recently, I think it's a couple of months ago or so, just published an article arguing that juries should only vote and not deliberate. For me, I mean, I can see, and I will get into that there might be second order deliberation and discussion about whether one should deliberate or not. That might be an interesting thing to explore. I'll go into that in a moment. But just the idea that decisions will be taken in law with no deliberation, for me, it's like, because it's not a political process in the same way in which voting can be. And we don't have the type of restrictions that will take, imagine if all the citizens have to deliberate about who is going to be the next president. So we don't have the restrictions of size that will make it completely inoperative. And it's a different thing, a political decision than a legal one. So for me, maybe I have a very old-fashioned idea of law being connected to reason. And I have a very old-fashioned faith in reason, which I do. But I think it's worth it to see ways in which one can develop the character of citizens and the character of public officials, and one can design institutions in ways that will make it likely that deliberation reaches good results, better than those that will be reached by solitary deliberation, rather than giving up on the ambition to deliberate and simply settling on voting, right? So I do think there are many reasons why deliberation is desirable, and actually I don't go into those in the paper. I just assume there is a mandate to deliberate, and I don't explore that, and this is like a paragraph. I'm happy that you pointed that out, because I can see this is a paragraph that needs to be expanded properly. So thanks for that. And I will. But just to share my puzzlement about the state of affairs, particularly among epistemologists, which of all people in philosophy, right? Then on this discussion of the first order and second order deliberation, which I think it's a very interesting one, which I haven't seen anywhere else. So I'm very curious to read more in your book about that, and whether there might be interesting reasons to be asked in a particular deliberative setting about whether it is worthwhile engaging in deliberation or not. And I was already thinking, I mean, not in terms of whether engaging in deliberation in general, or whether designing the jury in ways that they should deliberate or not is a worthwhile project, because I think, quite frankly, that there are very good reasons for asking jurors to engage in deliberation. But there might be interesting questions to be asked about whether one should deliberate in this particular setting about this particular issue, or whether we should just let it pass and let it go. And I think this is, which I think is also what you have in mind, right? So in a specific deliberative instance.
Yes.
Yeah.
Yes.
Okay. Yeah, I think this is a very interesting question, and I think virtue might be helpful here. There is this work by Cohen, in Argumentative Theorist, and he in a very, very nice way, he has a very nice writing style. He presents like some figures that he thinks we should be wary of. And then one of them, for instance, is the argument provocateur. So the person who is always provoking a discussion, always, and the extent to which this might not be the beneficial way to go. I mean, maybe there are arguments you should not just put up front, or maybe there are times at which you should just sit back. And I think if one understands the argumentative virtues according to this doctrine of the mean, of the Aristotelian one, then willingness to engage in discussion, which is one of the main argumentative virtues. I mentioned the willingness to question the obvious, the willingness to listen to others and to modify one's views. And the fourth one, which I didn't mention, is willingness to engage in deliberation. I think, as any other virtue, has to be moderated by practical wisdom. And it's not the case that one has to deliberate always and up to the fatigue, right? Because it might be sensible. There might be good reasons why. For instance, for group synergy in the long run, in a diachronic way. So courts have to be sitting and discussing many times with the very same people, sometimes for years in the case of constitutional courts. And there are also good reasons why you don't want to create a climate that of deliberative antagonism, antagonistic climate that might be not beneficial for future interactions within the court. So I totally agree. It's a very interesting distinction that I have not considered, but totally fits into I think, or fits nicely with a virtue approach to what an ideal deliberator should be. Then I have not thought at all about this distinction of virtues in decisional phase, pre-decisional, post-decisional. I have not thought of different types of virtues, so I have thought more of virtues being traits of character that will be helpful throughout the process. And I do agree with you that it's important not to focus excessively on the decisional phase, which is what epistemologists do with the peer disagreement model, in which they just focus, okay, we disagree, what is that I should believe? I think this is too restrictive a view of what disagreement involves, and it's a much more extended process. I'm not sure whether virtues will be different, but maybe they will be. I mean, because definitely, like, clarity in expressing one's point of view might not be that equally important in the different phases. So I will have to think about that, and I will read with a lot of interest the book chapter you mentioned on that. Then on institutional design, I didn't say anything about that, but one of the objections I raised in the paper, which is an objection that I systematically encounter every time I want to advance a virtue approach to anything in general, not specifically to deliberative virtues, but the reaction is that it is too idealistic. Is irrealizable. So we have to bring this down to earth, because at the end of the day, of course, it would be really nice if everyone had the virtues, but we don't. So we still have to operate in a less than virtuous world. And I resist that objection everywhere, and specifically in the context of deliberation, because actually, one of the main reasons why I feel attracted by a virtue approach to normativity is because it brings, it articulates a normative ideal that is in fact close to our kin. It's not a normative ideal that abstracts away from our capacities, cognitive resources, in the same way in which many other cognitive ideals do. I mean, Dworkin's Hercules is not a virtuous person. It's not a person to start with. It has unlimited resources, unlimited time. The virtuous person, on the other hand, is a normative ideal that we can actually hope to approximate. So if anything, it really has a lot of practical momentum, unlike other normative ideals. So this is why I feel very strongly about this objection. This is too idealistic. Actually, it's really not. Compared with any, of course, it is idealistic. It's a normative ideal. If we were all virtuous, we wouldn't need even to talk about virtue. But it's an ideal that we can take steps to come closer to, unlike other ideals that are too far removed from cognitive capacities and human psychology in general. So in this set, of course, it has to be worked out in detail, ways in which we can come to implement virtue. And one way would be education, of course. And the other one, which I merely mentioned, is institutional design. And I think this is a very promising route in law. There are ways in which these institutions can be designed so that even if they do not ensure that we will be virtuous, nevertheless, we will it facilitates, it promotes, it fosters virtuous behavior. And I think that business people are actually one step farther than we are in thinking of ways in which organizations can be structured so as to promote virtue. I know that for many people, particularly I think in law, the idea of business ethics is like a distorted view of ethics or something like that. It's like one doesn't naturally think of business and virtue as being like easy put together, but work in virtue ethics in business literature and managerial literature is really interesting, and one of the areas in which I think we have a lot to learn from them is an organizational design, how institutions can be organized so that people behave more virtuously, so that these are environments in which virtuous behavior is promoted. Then your last 2 points that you just said, like last 2 points, but they were like huge points. So I will just say something about each of those. The first one on compromise. Yeah, it's completely. When I mention compromise, I really put it in connection with pragmatic reasons, and I think I can see the point that there might be very good reasons to compromise that are not necessarily or exclusively pragmatic. I mean, compromise is a topic that really interests me. I may perhaps in the future work further on that. I thought it was it's a difficult, very difficult topic, and I do not discuss it except that in passing in the paper. But I do agree that there might be good reasons why within a court a compromise might be the best way to go. Of course, it will be second best, but perhaps not always. So I think I'll have to think more about that. But just to say that I will agree that there might be compromises that are not merely pragmatic. And in which the virtues, and I think this is particularly important for political virtue. I've done some work lately on the virtues of leadership, and this is a theme that all the time comes, more often than not as a justification of dirty hands and all that, but not necessarily so. So I can see that this is a compromise comes in many forms, and some of those might be not even second best, but really the virtuous way to go. And on genuine virtue, can we have really deliberation only if we have behavior according to virtue, or it requires honest deliberators through virtue? This distinction, for those who didn't have a chance to read the paper, is the distinction between someone, in order to have a virtue, to possess a virtue fully, one needs to have not only to behave as, for instance, generosity, not only to behave in the way the virtuous person behaves, but also to have the motivational and affective dispositions of the person who characteristically has the virtue of generosity, meaning the motivation of the generous person and the affectivity of the generous person. Not every time you give a donation, it breaks your heart. Then you will say, well, it's good that you did behave as a generous person, good, but you do not possess the virtue of generosity, the genuine virtue of generosity. So there is a virtue that is a behavior that is out of virtue, out of the virtuous motivations, and behavior that is merely in accordance with virtue. And then Conrado, you say, well, this behavior according to virtue does not live up to the ambition of deliberation, and yeah. So of course, I mean, the first, we should aim at genuine virtue, and we hope that deliberators in the different collective sites of legal decision making have all the virtues in a genuine way and not behave in accordance to virtue. And indeed, the best instances of deliberation will be those in which individual deliberators possess genuine virtue. Nevertheless, I think there is a lot to be said in favor of ensuring or helping people to behave in ways that are accordance to virtue, as if they had the virtue, even if they don't have it. And I'm not sure that this will prevent real deliberation from occurring. So I give, for instance, an example. Some people have the virtue of impartiality, other people are a bit biased or very biased and do not have the virtue of impartiality. And I think this is This is something that we encounter in every single collective site that we have of deliberation we've participated in. And I thought it was very interesting that there was this empirical evidence by cognitive psychologists indicating that actually in law that was used with legal subjects. I don't remember whether it was real sites or it was on lab conditions, that I don't recall. It was done by Dan Simon, a cognitive psychologist in collaboration with other cognitive psychologists and legal scholar. And he did this very interesting experiment in which he contrasted groups. Some groups within the jury were given were not given an instruction. Some groups were given the instruction be impartial. And other groups were given the instruction, consider that the opposite party, the one that you do not agree with, has a reasonably, what was exactly the framing, take seriously the possibility that they might have a case, okay? And interestingly enough, there was no difference between being given the instruction be impartial than with no instruction, because people think they are impartial already. Everyone thinks that they are impartial. So if you say be impartial, you're not going to do anything different from what you already do. Whereas there was a big difference between those who received instruction be impartial or didn't receive any, and those who received impartial consider seriously the possibility that the other case actually might have a good case. And this is a way in which these people obviously didn't have the virtue of impartiality, but behave in the way in which an impartial person would. Oh, yeah. And there was an enhanced deliberation in that they were taking seriously views that otherwise they would not have taken equally seriously. So the deliberation was better than it was before, right? Or it was in other groups. And to the extent that this is so, even if it is not ideal, I think we can still have an improvement in deliberation and genuine deliberation to some extent, because those views were in fact taken seriously. So there was a deliberation that was informed by alternative viewpoints. Okay, well, thank you so much for all these comments, Conrado. It's been really a lot of food for thought, and I'm sorry for giving you a second lecture in addition to the first one. Looking forward to other comments and discussions, but very many thanks, Conrado.
Thank you so much, Amalia.
We got a written question here. I would have a few questions myself, but as a chair, I would leave it to the end so more people can have an opportunity to ask questions. Okay. So we got a question from Emmanuel Linhares, who is a PhD student here in Belo Horizonte. I will read that for you. It's in the chat. It's excellent paper and discussion. Thank you very much, Professor Amalia Amaya. I would like to ask you a question, please. Would the deliberative distortions you listed in the paper theoretically be applicable to any constitutional court, regardless of the specific legal system, or would they have been inspired by a particular deliberative judicial model? So that's... It actually connects to a question that I would like to ask myself, which regards the impact of social practices in virtues and how they can become special. So I would leave that to you.
Yeah, thanks a lot, Emmanuel, for your question. Well, the deliberative distortions will be, in fact, biases that are not specific even to law, let alone to a specific institution or legal system. These are distortions, and I use the word distortion because there is some, I didn't want to engage, although in a next installment of the paper I will have to at some point, into whether these are biases or biases. There is some discussion in the literature about how to best characterize them. So distortions, I think, is neutral among different ways in which these problems might be characterized. But the idea is that these are biases similar to the individual cognitive biases that have been reported in the literature, such as for instance, the hindsight bias or the or all the biases that are associated to representative heuristics or anchor biases. So all these different type of biases that affect individual judgment, there are also, and that's a claim, a similarly a set of biases that affect collective judgment. And they have to do with group dynamics that are not exclusive to the legal domain, but are rather they are pervasive in every domain in which decisions are taken by collective bodies. Nonetheless, I did the corrective to those biases in the view I'm advancing, or one corrective. I don't mean to say that this is the only way in which those biases can be corrected, and I did say that in the paper, not in the talk though. So I think this is an important way in which they can be corrected or mitigated, but by no means the only one. There are non-virtue-based tools that one can use for debiasing, like, for instance, the Dolphin method, in which people write whatever it is that they think the results should be prior to deliberation, so that you are not affected by evidence of what other people within the group thinks. And this is a debias technique among many others. But this is nevertheless an important way in which these biases can be mitigated. And then when it comes to the specific virtues that are helpful for addressing those biases, in that sense, I think, although I do not develop or say anything in the paper, and I think I should, but it's a difficult thing that I need to further think about that. But I think that there might be some virtues that are more needed when one is performing the role of a constitutional judge. For instance, that if one is deciding as a member of the jury, or one is deciding as a member of a regulatory body, or one is deciding as a member of a first instance court, of a trial court. So in fact, I do think that depending on the legal system and the position of the body within the system, and whether it is within the judicial branch or any other branch, it might turn out to be the case that some virtues are more needed or more prominent than others, and that the expression of those virtues will vary with the deliberative context. So in that, I think a more nuanced analysis is needed. I don't know whether this answers your question. Thank you.
Thank you, Amalia. Would anyone else like to make a question? You can make also in Portuguese or Spanish, and you can also make it in writing or speaking, whatever. So would you like Henrique to say something? I think I saw you open the camera.
Yeah. It's a
Please,
short
go
question.
Yeah.
Okay. Hi, Amalia. It's a pleasure to see you again, even if still virtually. The question is basically that, well, I was reading your paper, and I always think about the epistemology of disagreement, I think of Susan Hack's criticism against coherentism, the drunken sailors argument, right? And meaning that basically, because coherentism does not allow a non-belief input and outside input from outside, and so there's no role for experience or the outside world or even peer input. As such, it wouldn't be a good theory on justification. So I was just thinking, basically my question is whether you have thought about this, is the interrelationship, perhaps even a critical interrelationship between coherentism and the relevance of taking peer disagreement into account, or the role of peers. So I really haven't thought this through. It's just something that I keep popping up in my head. So I hope this question makes some sense. Thank you.
I think you can answer it. Yeah.
Yes. Yes. Thank you. That is a very interesting question that I absolutely have not thought about, but many thanks for raising it. Indeed, peer disagreement is a type of evidence. So it's evidence that other peers are disagreeing with you, and as such, it could be, in principle, one could think that just as coherentism faces the objection that it doesn't take into account experience or evidence, so it's like this input objection that is sealed against new evidence, in the same way it could be sealed against taking into account evidence from peer disagreement. This is a very interesting way of putting it. I have not thought about that. Also because I have not thought about how this will connect up with a coherentist account of justification at all. So I suppose group belief could be justified along coherentist lines, and if this is so, then it will definitely have to face the objections of coherentism in general, including this input objection. So I'm not sure whether the general strategies that are used to meet the input objection will apply as well to the specific case of evidence of peer disagreement, because it will have to go something like, because when it comes to experience, the idea is that if you have a good system of beliefs, there will be second order beliefs that will say that most of the beliefs that come through perception have some degree of justification, and therefore that you are not justified in simply rejecting them. In the case of peer disagreement, it will be necessary to have a system of beliefs that will somehow give already some credence to evidence of peer disagreement. This will require then engaging, already endorsing a view about whether one should be conciliationist or steadfast, right? Or do you think it will be prior to this debate? It will be prior because it will be whether you consider that to be evidence in the first place, not how you should react to that evidence, right?
Yeah, just perhaps as I said, I haven't really thought about this, but I think it would be necessary to have like a standard second order belief about receiving peer input, right? If it would work both ways, right? If you have a coherentist set and people agree with you, that if that has an effect, you would also have to include a second order belief that operates whether people disagree with you as well. But I don't know in what level it would work.
Yeah, no, I think you're right. You will need to have in your system of beliefs second order beliefs that will give some credence to evidence of disagreement. The question will be like, for the strategy to work, though, we will need to think whether there is some justification for those second order beliefs. Because like in the case of observational beliefs, there is a clear justification for giving those beliefs some credence. I'm not sure whether the same type of justification will work in the case of evidence of peer disagreement. I will have to think more about that because I suppose if it is peer disagreement, like really not among political peers, which is what at the end of the end happens at the end of the day happens within courts, that it doesn't work the idea of a cognitive peer. What works actually is the idea of a political peer, someone who has the same status within the group as you do, which is different from the epistemic peers that are discussed in epistemology. So I think my reaction would be to say, in context in which the political peer is also an epistemic peer, in the sense in which it has the same capacities, availability of evidence and all that, there would probably be a good system of beliefs will include second order beliefs to the effect that those beliefs should enjoy some degree of reliability in their own, in the same way in which perceptual beliefs do. So that would be my reaction. Nevertheless, I think that in many cases, when it comes to law, this is not what happens. But a much more complex idea of political peer is in place that will make it less evident the sense in which evidence of peer disagreement should play a role or should be given an initial reliability. But thanks a lot. This is a very interesting question.
Okay, so would anyone else would like to make a question? Well, if nobody speaks up, I think I will just go to my questions then. I was very interested, Amalia, in the part that you replied to the idea that sometimes the decision just comes automatically or almost automatically. There's no intentionality here. That you just have develop some dispositions, because I think that this is probably the way virtues can help good decision making. Sometimes to question some norm is already to act immorally. so sometimes if you consider doing something, you're already failing to respond appropriately to reason. And I think that this is very interesting. So my question would be, I would have actually many questions, but one of these is like, I'm very interested in the way that social practices impact virtues and values. I'm coming from Rass's book, Joseph Rass, Engaging Reason. I think he has some very interesting chapters on mixing values and how social practice, they sustain new values by mixing the old ones. And in a certain way, creating new genres of valuation and appreciation, and explaining how new values come about without conceding to relativism. Because once a value has emerged, it is a real value. It transcends its context, but it needs social practice to come about. I think that this argument is very ingenious, very interesting, because it can explain something that happens in our context. I mean, how do we, in legal reasoning, have special obligations, special virtues that are not virtues in other contexts? And sometimes judges have virtues that are vices when it comes to other professions, like a journalist or even a prosecutor. And these specifications, I think that they go more or less in the same direction of what Conrado tried to do it in his book, which is, I really recommend it. It's a very good book, because you specify what is a virtuous practice, a virtuous disposition, and a virtuous behavior for someone to do X and for someone to do Y. I think that this is for some institutions which can be different from another. And I think that because these institutions combine values and virtues in different ways, there might be special roles and special obligations. And I think that I'm not saying that this is what you should do, but perhaps that this is something that you should do after you publish this chapter, perhaps in another chapter of the book, to try to specify the special obligations that emerge and some special virtues. I think that this is one of the, because I think that this is one of the ideas of classical common law. If you go to the debate between Thomas Hobbes on the one side and Coke and Hale during the Civil War in England, and Coke was arguing that there is some sort of special reason that applies to law, and not even you, the King of England, which is very well-trained in reason, master it, because you don't develop the proper dispositions to respond appropriately to reasons, which is an institutionalized. I think that this was a very important argument. Another argument that I can think, which was revealed in Gerald Postman's new book, Utility, Publicity, something on utility, publicity, and Bentham. And Bentham says that people can have sinister interests, which are just self-interest, not proper dispositions, but institutional designs can help people contain these interests. And publicity is a value that can make people avoid or curb these sinister interests. So you can see how these topics come together, like virtue theory on the one side, institutional design on the other one. So that's another thing that I would like to just give to you to see if you want to do anything with it. And the final point is that I think that sometimes the division between rights theories, arguments from principle and arguments from virtues, or rights and virtue ethics and utilitarianism and all these things, like all these traditions, they are so separated that we miss a lot. because I wonder if a good theory of judicial reasoning cannot incorporate elements of all of these traditions. You mentioned working, and I find something very interesting in working, which is the idea of associative obligations. Like to join a political community, you must necessarily take up some obligations because because the mere fact of membership carries with it some duties and requires some virtues and some dispositions and some reciprocity requirements. I wonder if we can combine some insights from a rights theory with a virtues theory and perhaps some utilitarian theories as well. So without making a big syncretic mess, but I think that perhaps there's a way to do it. So let me hear your views on these possibilities. Thank you very much.
Thanks a lot, Thomas, for these comments. Yeah, I bought a pulpito, but to these talks and all that. Now that we have to. So it's really like a priest pulpito in a way, but it turned out to be a bit low, so I keep on on doing that. Sorry about that. Okay, so thanks a lot for your comments. And let me see how I could react about the first one about the virtues per the immediacy of the virtues response. This is a very interesting topic, I think, and I actually plan to write like soon an independent piece on that, because I think it really is necessary to understand the way in which I mean, what will be a model of virtue appropriate for the legal realm? And there are different models of virtue, different ways of understanding virtue, and some of those emphasize more than others the role that immediacy and intuition play in the virtuous response, and others include or lean more towards like a reflective mode. I think it's important like to find a way in which actually we can have both a component of intuition and a component of reflection, among other things, because I think a virtue, if I may say so, of a virtue approach is that it's more psychologically plausible than other approaches to reasoning, in that it has a natural way to combine system 1 and system 2 processes, cognitive processes, the one being the one of intuition, emotion and all that, and the second one, as is well known, the system that has to do with reflective abilities. And I think that unlike other, for instance, a principle-based approach to legal reasoning that will put all in the basket of reflection, a virtue, the notion of virtue accommodates easily the way in which reasoning involves both systems, the intuitive level and the reflective one. So I think it's very interesting to see the sensing which type of model of virtue is more appropriate to law. And I think you're totally right. And I didn't discuss that in the abstract of the paper, so I will take good note of that, that we don't want to have so the main approach to virtue, which is the McDowell's approach, and has been very influential in virtue ethics and elsewhere, is this idea of virtue as being an intuition into the right, having like an immediate response. And so the virtuous person just sees what has to be done. And I am wary of that approach to virtue because it justifies a very elitist approach in that it's either you have this sixth sense or you don't have it. It makes it a mystery as well, the way in which virtue develops, because how I'm supposed to come to this vision that the virtuous person has and other people do not. And I think it's also incompatible with publicity. Coming back to the book, because I mean, it's not only that you need to see what this has to be done, but you need to be able to provide and articulate reasons why this is the right decision or the right course of action. So I'm a bit wary of an intuitionistic approach to virtue. But then on the other hand, you're totally right. And my main argument against that is all these three reasons why I think it's not important. But I didn't think of the sense in which having a virtue, on the other hand, should require or should preclude sometimes deliberation. So if I have to deliberate about whether I should kill you or not, then I probably lack a virtue. Because this is not the type of question that a virtuous person will deliberate about. So we have to frame, to have a model of virtue that gives a space for deliberation, so that it's not purely intuitionistic in the way in which McDowell's model is, but not that it gives so big a space that will make it possible for a virtuous person to deliberate about whether, so that there is some space of deliberation that should just not be there for the virtuous person. And I completely agree. I have a sense that the idea of the models of virtue that build the notion of virtue by analogy with skill, the expert skill, so that the virtuous person will be like an expert in the practical realm by analogy with that. I think it's interesting because experts on the one hand have an immediate response. So it's not that an expert in I don't know, in wines, for instance, an enologist, it has to like deliberate all the time about whether this wine is better than this other one. They will have an immediate response because they have already internalized like the standards of quality and how to assess the goodness of a wine, to give an example, or a scientist in a lab. But on the other hand, sometimes there are situations in which deliberation is called for, even for the virtuous person. So I tend to think that what distinguishes the virtuous person from the novice is not that they do not need to deliberate at all, because it's like a second nature and they will always know what to do, but rather that in many cases that are difficult for the non-virtuous, the virtuous person will have that immediate response. And there are also some cases that are even difficult for the virtuous, but unlike the novice, the virtuous will have the resources to deal with these very difficult cases, but in ways that include deliberation. So this is the way in which I would like to find a way in which virtue will include both intuition and deliberation. But that's, I think it's yes, definitely. And also, I mean, it's a way, the virtuous person is not a continent. So it's not the person who has a tendency to do what shouldn't be done, and similarly should be understood as someone who does not have any need to deliberate about certain things that are out of the domain of virtue. So I completely agree with you, and I think this is a very interesting twist in this discussion between deliberation and intuition that I had not considered actually. So many thanks. On the social practice, I have a sense that we might disagree here, but maybe I'm wrong. Because you said, I mean, there are some traits of character that judges that will be a judicial virtue, but then outside of the role of judge, it will not be a virtue. So there is like a special type of character trait that.
No, I didn't mean character trait. I meant norms, special rules. I mean, there are things that as a judge, you will be a bad judge if you do often. For instance, comment cases in lectures. I mean, perhaps it's a good thing a professor does, but not a good thing a judge does.
Okay.
I meant more specific norms.
More specific norms.
Yeah,
okay.
Yeah.
Because my view on that, which has to be worked out, and this is the second part of the book, deals with ethics and judicial ethics specifically, and this is something that I hope to develop in more detail. But in my first approach to how to deal with that is to think of, I like morality, including the morality of the professions, being more in a continuum. So I don't like in which, if it is especially something that is over the general obligations that we have. But I don't like the idea of the morality of role of being something independent or autonomous from general morality. I like more the idea that was put forward by Christine Swanton, distinguishing between prototypical virtues and professional virtues, so that all the professional virtues are somehow specifications of general virtue. So it cannot happen that a trait of character that is not a virtue, that is a vice outside the professional role, turns out to be a virtue within the professional role. So a lawyer who lies is doing something wrong. I mean, lying cannot be something correct within the context of the lawyer if it is not correct in the realm of general morality. So in that sense, I think what will be different will be the prominence of some traits of character and the expression of those traits of character. So what honesty requires in the context of the role of a judge or the role of a prosecutor is not going to be the same as what it requires in the context of a friendship, for instance. So the expressions of the virtues, the demands of the virtues will be tailored to context. And I can see this idea of like having a special responsiveness to legal reasons that someone who is not within the role will not have. And indeed, I think, but this I think can be explained as well in terms of broader character traits. Like loyalty, I think is a very important virtue in the context of the judicial role, but in the context of the judicial role is loyalty first and foremost to the values of the legal system. And in that sense, it will be different from possibly the responsiveness or how tuned the person is to seeing the requirements of loyalty to law. What loyalty to law requires is something that someone who is not within the role of the judge will not get it. And I think this is what was the first example you gave of this special disposition to respond to reason. The historical example you gave?
I meant the debate between, it's a fascinating debate between Thomas Hobbes and Lord Coke during the English Civil War, in which Coke claimed that, look, if you're talking about, if you're deciding cases, you must do it through certain processes. In certain ways, and there must be public reasons, and there must be the principles of natural justice. There is an artificial rationality that applies to law. That's not the same reason that you have. So you as the King of England, he argued that in front of King James, who wanted to put a case in the Star Chamber to revise a decision that had been already taken about the limit. So it was a debate about the limits of the royal prerogative. And he managed to convince everyone that the king is not sufficiently learned in the proper rationality of law. So I think that this became a very powerful, and it is still today a very powerful argument in the common law, the idea of an artificial reason. So that was
yeah.
Situation.
Okay. No, very interesting. I haven't read that. Very interesting. But yeah, I think he has a point in seeing that the ways of reason within the law will be to some extent different or restrictive in terms of the kind of reasons that can be accepted and the type of loyalties that have to the legal values, regardless of whether these are your values or not, including formal values like following procedures and all that will be working within the context of the role of a judge and not in other non-institutional roles. So there will be a need.
My point, Amalia, is that I think that this argument of artificial reason, it's a point of intersection between the value of the rule of law and the judicial virtues.
Yeah. Look, I mean, when I come, which I didn't mention here because it was deliberative virtues only, in my description of what are the main types of virtues that judges should have, there is a set that is called artificial virtues. Following. Exactly. Which includes loyalty to law and justice. So I suppose this type of considerations will be within these artificial virtues. It's badly received, the idea of artificiality, particularly when it comes to justice. So people feel that justice should be something more natural and less artificial. When in fact, I mean, it depends. So less dependent upon conventions. But I did like the idea of Hobbes' artificial virtues and included it in my list. And now I'm thinking about changing the name because of the reaction that somehow people feel like a bit uncomfortable with categorizing justice as an artificial virtue. But I might reconsider after thinking of the artificiality of reason, which I totally agree with you.
I can send you just two very short pieces on this by Postma, which I find brilliant. It's an article called Common Law, Classic Common Law Jurisprudence. It's brilliant, and it explains the idea of artificial reason in the common law literature. I think it. I don't react in the way that you suggested. I mean, like people become like resistant. I find it it's the best way to frame the nature of legal reasons. Then, if you compare legal positivism and natural lawyers appealing to something that is transcendental, and legal positivists claiming that all that you got is conventions. So there might be something in between.
Artificial.
Artificial, yeah. Artificial while responsive to reason, yeah.
Okay, yeah, no, so it might I might do well in keeping it because it's true, and maybe emphasizing the extent to which is different from conventionality, artificiality and conventionality. And this is the key to this is, thanks a lot. This is the key to, because I publish it and like every time it's like, oh, this artificial thing doesn't quite, because then natural people who have more natural inclinations feel a bit left out. But maybe that's the key to emphasize the distinction between conventionality and artificiality. Thanks a lot. And then the final point of a good theory of legal reason should give a role to consequences and principles. Absolutely. No, absolutely. So I don't think it has to be just one thing or the other. I think it's so my point is more that a virtue theory has to, I mean, it's tricky because I'm presenting it as an alternative to principle-based approaches to legal reasoning. But by that, I don't mean to say that principles should not play a role. I do mean to say, but this is something that troubles me, but I do mean to say in principle that virtues have a priority over rules, in that the virtuous person might decide that the rule should be defeated in the particular case, given the circumstances of the case. And in that sense, there is a conceptual priority, but by no means should it be understood in the sense that a theory of legal reasoning should not have a very important space and role for rules and principles. And I will be happy to say that not only in legal reasoning, but also in moral reasoning or epistemic reasoning as well. So there is no need to see those as antagonistic categories that should be exclusive, not at all. And likewise with consequences, by the way,
Thank you very much, Amalia. That was a wonderful session. I really learned a lot, and I thank you for sharing your work and your insights with us. It was a fantastic evening. Conrado, would you like to say something before we end?
No, I think I would just like to thank Amalia again, and let's keep engaging with this topic. I've been a bit distant from my PhD and my book, but I definitely want to develop more points, and it was really enlightening to see these lights of the epistemology of disagreement literature.
Okay, so thanks a lot for the invitation, Thomas and Conrado, for the comments, and the participants for both comments and for staying with us, and well, it's been also a very enjoyable session for me, and I've learned a lot as well. So very many thanks. This is going to be very useful, not only for the paper, but for the broader project as well.
Okay.
Bye-bye, Amalia.
Bye-bye.
Thank you. Bye-bye.
Bye, Thomas.
I will send you the link of the session, so if you want to go back to it. Okay.
Great. That's great.
Wonderful. Thanks everyone for coming. Bye-bye.
Thank you.
Stop recording. Yeah.